$40,000.
Thank you.
Thank you. Thank you.
By my watch, I think we have just about 16 minutes.
Thank you for your attention tonight. My name is Mitch. My answer is yes.
In addition to what you wish to share with this board, do you have any evidence or information that would indicate the application would violate the Yankton County zoning ordinance if approved?
I do.
Thank you.
My name is Mitch Petersen. I'm an attorney at the Davenport, Evans, Hurwitz & Smith law firm in Sioux Falls. One of my primary practice areas is zoning, predominantly CAFOs. I have been involved in probably 20 of these in the last 5 years. I think every zoning decision from our South Dakota Supreme Court over the last 5 years have been my cases. I have been before probably 2/3 of the county's East River. So I've seen a variety of ways of how things are done, and I have quite a bit of experience. I'd like to share that with you because it's readily apparent that the process here just doesn't comply with the ordinances, and their application doesn't. And ultimately, it's not about what you as board members have done wrong. It's not a criticism of you. It's an issue of have the applicants met their burden. It's their job to make sure that they give you the information to prove that the ordinances are met. And if they're not, you just can't say yes to it. Even if you want to for economic reasons, there are rules that have to be followed. And it is the applicant's burden to prove that. So it's really about whether they've met their burden tonight. It's not about you in particular. In particular, under Section 1905, Subpart 6, this is the conditional use permit regulation that's applicable to Board of Adjustment proceedings. That's what we're doing tonight. It's the conditional use permit decision. A building permit is a separate process. They could build this hog confinement facility and use it to store hay. But if they want to use it for hogs, they need a conditional use permit to do it. So that's why we're here tonight, to find out have they satisfied the burden of proof. And under 1905-6, it says before any conditional use is issued, the Board of Adjustment shall make written findings certifying compliance with the specific rules governing individual conditional uses. Those are found back in Article 5 that deal with CAFOs. So this thought about we don't need our details, we don't need to give you our engineering report, which I've seen, an engineering report is typically between 90 and 120 pages long. Every single Board of Adjustment I have ever been in front of in the last 5 years has those on the night you're doing this. And it's been available to the public for study for at least 10 days, which is not nearly enough, but that is minimally compliant with due process. They have the cart in front of the horse here. They absolutely do, because your time to determine whether your conditional use requirements in Article 5 are met is tonight. It's not later when they want a building permit. Because if you say, now we want to go back and look at this, they're going to say, tough, you had your chance back on July 5th to take a look at it. And if you deny it based on that, you're going to get sued. So tonight's the night to look at it. And it's not for DENR to look at county requirements. DENR looks at exclusively Clean Water Act compliance and water regulations of the state. They do not look at air quality at all. They will not look at odor. They will not look at anything other than water, because it's a water discharge permit. That is the only thing that they do. And additionally, as their engineer, Mr. Warner, stated, often county requirements are more stringent. They're stricter. They're harder to meet than state requirements. But you know what DNR does if their requirements are met but the counties aren't met? They grant the permit, because it's their job to deal with state regulations. It's your job to deal with county regulations, and that time is tonight. A bit about risk. That's what lawyers do. We deal with risk all of the time, and that's what all decision makers do. You have virtually no risk in saying no tonight, because you might collectively have 10 different reasons why you shouldn't grant this permit. It's not good for the economy, it's not good for air quality, they're missing different, whatever it is. Say you've got 10 of them. If they appeal to a court and the court says, you guys were off base on 9 of the 10, but you're right on one of them, you know what happens? The court says you made the right decision. On the other hand, if you grant this permit and we appeal, and we will, and I've done it all the time, I'm used to doing it, and have a petition out in 48 hours. If we put up 10 reasons why you shouldn't have granted the permit, there's 10 different reasons why you had no authority to do this, we only have to win one in court. Only one. So there's a lot less risk in saying no tonight. You've got a lot of shade and a lot of cover based on how the law works. Additionally, you avoid liability with unconstitutional takings, due process issues, Section 1983 claims, nuisance claims, reimbursement claims from farmers who's now have junk on the fruit that's going into schools. You avoid all of that liability. A bit on how the ordinances work. Article 5 are your CAFO-specific control requirements. These are the things that only apply to CAFOs. There's all sorts of other conditional uses, but it's Article 5 that deals with CAFOs. Article 19, and in particular 1905, is applicable to all conditional use applications. So whether it's a CAFO or any other thing on that list, there are other things that have to be met. So if the applicant hasn't done their job of putting an engineering report on your desk that shows detailed compliance with everything in Article 5, you can't say yes to it. I mean, under your ordinances, that's just not within the authority that Yankton County Commission has granted to the Board of Adjustment. You have to say no. But even if they've met all of those requirements, you still have a decision to make under 1905. You have a decision to make. You may grant it, but you aren't required to grant a conditional use permit just because Article 5 is satisfied. 1905 requires the exercise of discretion and judgment. Is this the right idea for the community? Specifically under 1905 6H, you have to decide, even if all of the specific CAFO requirements are met, is this generally compatible with the neighbors and the adjacent properties? And particularly, is this in the public interest? So I'd submit to you, you've got an important judgment call to make tonight, even if you believe all of the CAFO-specific control requirements are met. You don't just turn your brain off then. Now you're making a decision for all of these people out in the room and all the other people in your community of what's the right decision, what's the right policy decision. And you say no on that basis, you're never getting reversed by a court, because the court's not going to reweigh whether you made the right decision and weighed public interest correctly. That's inherently within your discretion to make that decision. On to the specific merits of Article 5 and the CAFO-specific control requirements or performance standards. Again, under Section 105 of your ordinance, it says that every rule throughout the entire ordinances are minimum requirements that have to be met. Minimum requirements. So that's important to think about when we get to Article 5. In particular, the fact that 6 out of the 7 applications have requested a variance conclusively demonstrates they do not comply with the requirements. Otherwise, they wouldn't be asking you for a variance. That is your proof right there on the next 6 barns that are coming up. That they're asking permission not to follow the rules admits that they're not following the rules. It's that clear. Otherwise, they wouldn't be asking for permission. Number 2, under the definition of an animal feeding operation in your ordinances, what class are these CAFOs? Are they really Class E? Because under the definition for an AFO, animal feeding operation, if there's commonality of ownership within a mile, then they have to be considered one CAFO if they're within a mile. And that is the case for some of these. Additionally, even if they're not more than a mile apart, if they have a common area for manure disposal, they are considered one CAFO. Even if all 7 of these, if they're using the same system, same manure hauler, and using the same contracts, you have to consider them as a whole. Your ordinances say that. And you haven't been given the details about what their manure management plan is to know whether you count them together or not. I don't know how you're supposed to do your jobs when they haven't given you the documentation to do the important work that you need to do. It's not your fault, it's their fault. They didn't do the work that they needed to do. They got the cart in front of the horse to try to float this idea out, which I think is pretty telling about the level of diligence and attention to detail they may provide as operators once these things are up and running. So I'd submit to you that your very first job of determining which class it is, so which rules are we looking at, you can't even answer that question based on what they've given you. So you got to say no for that reason. Say come back when you've got your ducks in a row. Number 3, there's no engineering report. Again, this is completely unprecedented to have no engineering report at the conditional use hearing. I've never seen it before. And it's required. Under 519 Section 10, a facility management plan is required at this point in time. 519.10 requires it, and it has a bunch of stuff that has to be in it, including what is their system for manure collection, storage, and treatment. Why would that be on there? To determine whether you count these together or not. I mean, that's one reason why that's part of what your facility management plan requires. They have to explain how they're handling dead animals, what they're doing for screening and buffering to try to control noise, glare, odor, flies. They have to provide information to you about the prevailing winds. I've yet to see a CAFO application that doesn't have an odor footprint study. You know nothing about where the odor is going to drift. You have to have that and know about prevailing winds and topography in order to make a site-by-site and site-specific decision about what additional controls may be required. They haven't given you the information to do the important work that you need to do tonight. Additionally, that facility management plan needs to have within it information about the topography, stormwater management, manure removal and application to make sure that they're meeting the manure application setbacks, which is different than where the CAFO itself can be located. There needs to be industry best management practices included. They don't have that. And there needs to be information about climate and weather information. They don't have any of that. It's required under 519.10. Additionally, under 519.7 and 5, it talks about various setbacks that are measured from the CAFO structures to various things that would be surrounding it. We don't have information about where those are. To measure from point A to point B, you got to know where point A and point B are. And they haven't provided the information about where their structures are. I'd submit to you, there's no possible way they could prove that they've met the setbacks. And I was at the auditor's office this afternoon. I was told there's been nothing else new, and now we find out maybe there's some other site plans to which the public had precisely zero access to even read, let alone study, formulate thought, and come here, prepared to oppose it. That's a due process violation right there. That's a slam dunk up here. Again, who is running the operation? Section 520 of your ordinances state that if any application is being sought with the intention of transferring ownership, control, operation, that itself is, you have to deny it for that reason. You need the real person who's actually be running this to come here to look at you and answer your questions. How is it that 7 of these somewhat unrelated people all have the same lawyer, the same engineer, all at the same time with exactly the same footprint? What is the story? And I'd suggest to you, we don't know the story. For that reason, you've got to say no. I do want to talk about variances. I can save that to later because I know I'm nearing the end of my time. But I would ask the comments I've just made, will they be considered for all 7 hog barns? Good, I appreciate it. Would you like me to address variances this time, and then I can, in all likelihood, stop talking for the night?
No.
Okay, I'll wait to do it. All right. Appreciate it. Thank you.
I would entertain a motion to go to executive session.
Wasn't on the agenda though, was it? No. Wasn't on the agenda, was it, Don?
No. Vote for the public to hear it.
So much for due process.
Do it now. Vote.
It has nothing to do with,
Here.
my suggestion has nothing to do with due process. It has to do with what's right for the people in this room.
Then you should share it with us. I'll go down with you. We're all sitting right here.
Rob, was it on the agenda to go to executive section?
Nope.
Here, you've seen the agenda.
Sir,
I'm sorry. What?
Let's hear you.
Well, I want to know from our two attorneys then what their opinion is. Pardon? What?
You guys as attorneys, you
I would like to hear from these two attorneys, Rob Rins.
said our two attorneys. Hey,
That's right, you're right.
Yeah.
Rob,
It wasn't on the agenda. It's not.
okay, then I would like to hear from you, your opinion on Mr. Peterson's, sorry, I'm sorry, position.
Okay. My understanding, what we're doing, this is all conditioned on them making sure they comply.
Rob, will you go to the podium?
Don, regarding the references and what's occurring, is my understanding what we're looking at is it's conditioned on the successful completion of those certain requirements in our conditional use. So my understanding is what we're going to do is we're going to have that. If this passes before this board, then they're going to have to come back and show that they've complied with all the conditions that we're dealing with today.
That's not the law. Compliance first.
My concern is listening to Mr. Petersen. I believe he brought up some facts of the law that don't allow us to do that.
Don, my position is that we can proceed forward with those being conditions that they have to comply with.
No!
If that's what the board decides to do, Don. My position would be that they can do that.
That's my position.
Don, have you permitted the podium for a moment?
Was he signed up?
Yes.
As to the issue of due process and the provision of additional information to this board, there's nothing under the law that says the information in your packet cannot be supplemented ahead of time with additional information that wasn't there ahead of time. There are laws that require certain information be published ahead of time. That would be notice of this hearing so that the public knows what the agenda is and they have an opportunity to respond. But if the site plan is more thoroughly developed at the time of this meeting, it only makes sense that you guys be given the latest information that's available. So you guys do have in front of you an updated drawing overlaid over the satellite image showing the actual footprint of the barns in each application, as well as the truck turnarounds and the loadouts, and that information is to be considered at this particular meeting for purposes of due process. It's one of the pieces of evidence you may be presented at this hearing in order to pass due process muster. It is your job to sit in judgment. It is not the public's job to judge these applications. They have an opportunity to come in and share their opinions and their feelings and their belief and their evidence.
My concern is the degree of completeness of the application.
Right. I understand that was...
Quiet, please.
That was the issue that was raised, but I believe it's a red herring legal issue because if the building permit is conditioned upon those things being done, all those items that are in chapter, I believe 519, as cited by Mr. Petersen, will be addressed. They have to be addressed as part of the conditions that are imposed upon these facilities in Yankton County. It does not have to be done
help
at the time.
me understand this,
Sure.
then, and maybe it'll cut to the quick for me. Why then, and maybe give me examples when they've done it the way we're doing it versus done it the way Mr. Petersen has suggested.
Well,
they're doing it in the rest of the state.
I'll be honest with you, Commissioner Kettering, I do not know how they do it other places. I'm confident that what we're doing here is legal. There's nothing under the law that says we cannot do it this way. And quite frankly, the issues that are cited in our ordinance as the considerations you guys must make in your role as Board of Adjustment in approving a conditional use are part of the information that I was intending our engineer, Mr. Werner, to share with you, because we have addressed a lot of those issues as part of what you see in front of you. All of those items were not available at the last meeting other than in concept form. We now have it in writing in front of you to consider at this particular meeting.
The problem is, or help me understand this, the problem is your witness didn't sign up.
Well, I viewed it as, pardon my frustration. The issue that I had is that's part of the applicant presenting his application. We're entitled to bring in those who can help us address the issues we are not technically capable of addressing ourselves. He's not a witness on behalf of the public, yay or nay. He's our hired engineer to help us present this project on behalf of the applicant before the commission.
Audience,
He was the person who created the drawings you see in front of you.
Please let us work through this without the comments from the audience.
Mr. Werner is the individual who created the drawing you see in front of you. He is the one best capable to explain it, which is why I tried to yield this time, but I got equivocated quite substantially by Commissioner Swenson.
Mr. Chairman, can I ask a question?
Todd.
And that's not a dig.
We've allowed both sides to have representatives speak on their behalf. Legal, wouldn't an engineer fall underneath that representative per the rules that we have set forth? They're a hired representative that have been hired to explain what's going on. Is he not a representative for the applicants?
By my look, I'd answer no.
Rob, can I ask a legal question on that?
Yeah,
And you might have to get to a mic so everybody can hear you.
I believe the answer is yes. I mean, obviously, you can speak on behalf of the applicant, you know, Warner again.
We're talking about procedures, Rob. We're talking about procedures. And they're challenging the fact that they didn't have all the information in front of them in the prescribed manner.
This was loaded in the packets.
I don't care when it was. He didn't sign up to present it.
And I don't think it's necessary at this point, but we have additional information if you care to hear it. That's all. That's my point. We have additional information if you care to hear it. We can address a number of those items that were going to be put off as part of the permitting process, which they would be very thoroughly covered as part of that process, but we also have some of that preliminarily available for you to consider today. It's a courtesy you may wish to enjoy. It's entirely your call.
I give you another.
Pat?
So I have to give the board another, you have a similar circumstance going on out there, and that is the telecommunication towers. Now, as we've gone through those telecommunication towers, they're very much the same way. When they have come in with their tower proposal, all we had was the site plan. We did not have the tower construction. We did not have all those things. But the building permit would not be issued until they brought the structural engineering plans and everything with it under our guidance with our engineers before we issued the building permit. But you did issue the condition saying, here's what you are going to do. And we have done multiple towers in Yankton County since under that premises. We have said, here's what you're going to provide us. In our findings, we have said, here's what you will provide us, and it will be done prior to the building permit being issued. And each and every one of those towers has had a building permit issued after all that material was presented. So I just want you to see your other standard. This is very much the same standard set up in the context of being outside engineers have to develop the plan.
What's the hazard of one of those towers?
Health marks compared to towers.
Quiet, please. Where are we at in the process?
Well, Mr. Chairman, I still believe that a representative for the applicants, whether it's an attorney or an engineer, can maybe answer some of these questions that have been posed today. I do, I would say that we should allow the applicant, we allowed him 10 minutes, so I don't believe he used his 10 minutes.
You get 3 minutes left.
We yielded all our time. What's the rest of you?
We want the lawyer's time back too.
Mr. Clemish, in these packets that we received with these diagrams, it's easy for me to see which way is north just by looking at road. Would this qualify as, they have locations circled on here, they have buildings on here. Does this qualify as formation of that Article 5 process?
Ray, I apologize. I have to look at the
Okay.
packet, so
Maybe if it was available before today.
Yes, it was.
You can't make a decision based on what you got.
No, are we gonna, Mr. Chairman, are we gonna let the representatives speak or not?
I don't have a problem with letting the representative speak, but I don't know what 3 minutes is going to do to the process. I like the clean water, knowing the factory farms just.
Mr. Warner?
Go ahead.
3 minutes, is that?
I guess I would prefer to have a 30-second conversation with the attorney to confirm that I'm addressing. You can start the time.
Yeah, it's okay. I wasn't timing all the applause. It took a little bit. Approaching 2 hours on the first one.
Clock started, right?
I think the 30 seconds is up.
Did you want me to start it?
Okay, come on back.
Okay. So the permitting process has already begun. They've started the paperwork. They're running down the road through all the steps they've got to go through here. In a matter of time, they will have substantially more information. They will have some of these plans.
Quiet, please.
Fleshed out. So if you guys want some more certainty, some opportunity to discuss with legal counsel when you're not on the spot here, we are amenable to tabling for a meeting if you like, so some of this stuff can be fleshed out.
In 2 weeks, can you have all the information that's needed?
I'm certain they couldn't have all of it done by the next meeting. I mean, keep in mind, it's also multiple thousands of dollars to put this stuff together, and with the uncertainty that this commission might not approve it.
That's the challenge that everybody.
That's the challenge. You're right. It's
Quiet, please.
Quiet, please.
I think Mr. Garrity hit it on the nose here in the sense that we don't require the same of the towers, and it's a similar sort of permitting process, and it is a great investment.
Quiet, please. Quiet, please.
I think that the information you've been provided gives you enough detail for you to check the boxes that you have considered those items in the ordinance if you wish to proceed. I think that this is legally supportable. If I didn't, I would not have presented this on behalf of my clients.
Mr. Denner,
we would have provided more information.
In 519, In 519.1, it says animal feeding operations shall submit animal waste management systems, plans, and specifications for review and approval prior to construction.
Correct.
Is that not
The
what
next,
we're doing?
the next
That is what we're
outbreak,
doing, 'cause-
without somebody acknowledging the chair for permission to talk, I'll ask them to leave.
That is exactly what we're doing, is prior to construction. The building permit cannot be issued until that's done.
And point 2 says prior to construction, such facilities shall obtain a stormwater permit for construction. So, I mean, if we put those conditions on the conditional use permit, isn't that
That's how we comply. We're following the ordinance the way it's written. This is one of the most challenging ordinances of its type in South Dakota to try to pass. I mean, this was a very landowner, homeowner friendly, agricultural hostile ordinance, and we're complying with it. It's just hard because you can't make people happy. Nobody wants this by their house. I wouldn't either, but this is what we permit in an agricultural. This is what we permit in an agricultural
Hard for
district.
me to clear the whole side of the room, so I'll forget this one. Please?
Please be respectful of everybody. We're trying to be respectful of all wishes.
The engineer says that a month we could get you a substantial amount of additional information.
Sir,
It still
you want
wouldn't.
to talk? Please come up.
Well, let's
Come up to the mic.
Can you finish his statement?
I just wanted to know how long you had.
Come up to the mic, please, and address the mic. Thank you.
he's not done talking yet?
Yeah, go ahead and finish.
The engineer tells us that in a month we can get you a substantial amount of additional information. It wouldn't be everything that
I
you're
just
asking
wanna
for,
know
but it
how
would be a
much
lot.
paper-
Sir?
Wait your turn.
Oh, I thought you
You're in
told me to
line.
come
You're in
up.
line.
In a month you'll have a substantial amount of additional information to consider. It still wouldn't be everything, but it would be a lot more because the process has already started.
Okay, thank you. Okay, go ahead.
I literally was just asking how long
Please
he
state
had
your
to
name
talk.
Your name, please?
My name is Matt Seiler, and I was just wondering how long he had to talk because it seemed like he was getting more time than the rest, and we had to give out our time.
Time issues was presentation to the board. When we ask questions of other people, we don't put a time limit on that.
Oh, so we can just ask or go however long.
Yeah,
I don't know how it all works.
Go ahead and speak.
But anyway, okay, well, so then the next thing is I would assume that with what our lawyer said, that nobody here has enough information to make the decision that you're gonna try to make tonight. So, I mean, I guess that would be probably pretty irresponsible to give them a go-ahead on this until other stuff's here.
You know, there's one thing about it, it always takes two lawyers to figure something out. So there's differences in opinions.
Well, no, I understand that, but I mean, you even said yourself.
That's what we're trying to get at.
Yep, I get it. Well, that's what I'm saying. Even though there's a question, I would assume that you probably are smart enough to know it's probably not going to work out.
Don't assume I'm smart. Okay.
May I have 2 minutes to respond to some?
Yes, you may.
I appreciate it. Try to be as efficient as I can. You know, if all the information, if it's okay for it to all come in now without any chance to hear, like, what's the planning commission hearing about? Or they're supposed to make a recommendation to you. I mean, the ordinances say you have to have a recommendation from them. Either yes or no, but you need to have a recommendation because they're the ones who are supposed to do the initial study for you. They've not studied this plan because it just arrived today. I mean, it wasn't at the auditor's office at 2:30 when I went to ask for it. So what's the point of the planning commission hearing? It's got to mean something. Additionally, you know, your choices today are, well, I mean, you could table it, but I mean, it's yes or no. That you're either going to grant them a conditional use permit or you're not. You can't give them a maybe. You can't say, yeah, it's looking pretty good, fellas. It's a tentative yes. Let's come back in a month or two when we have your engineering plan. And when you're looking at a building permit, it's too late then. You can't then get back into whether, it's just then, does the building meet whatever building requirements there are? It's too late then to go back and look at whether they comply with conditional uses, whether you look at things like in 519.10, like prevailing wind direction. It's too late tomorrow to look at that. Tonight is your only opportunity. And I notice Commissioner, I'm going to kill your name. Can I call you Deborah, just not out of lack of formality, but when you're looking at the 519 and reading, doesn't it say prior to construction in 519.1 and 519.2 prior to construction? Yes, those do, but you got to turn the page. You got to turn the page to 519.10 that talks about the things that are supposed to be in front of you. And 519.1 is not applicable to Class E's anyway. It's only Class A through Class D. So, I mean, they're time to comply with whatever the conditional use requirements are. Setbacks. Do they have a common ownership such that you really need to look at these as a Class D or a Class C or B? You've got to have that information now to even know what rules you're supposed to be applying, and they just haven't given you the information.
Mr. Chairman, I got a question for our state's attorney. Our options to table, yes, no, we have an option to send it back to planning and zoning.
Further discussion? I'd entertain the motion.
Mr. Chairman, I make a motion that we approve Carl Schenk #1 variance.
Wow.
We have a motion. Do we have
Conditional
a
use
second?
variance.
Man of God.
Hearing no second, motion dies.
Mr. Chairman. I'd like to make another a motion. I make a motion we send these back, this one back to planning and zoning to provide the information needed in the conditional use permit.
Everybody hear the motion?
The information needed for the conditional use permit, i.e. the site plan, manure management. Information will come out of the state permitting process.
You want the state permitting process to be done before it's approved by planning and zoning.
Let me clarify my motion. Pat or Rob, before I amend my motion, what are we going to, per our zoning rules, can you give guidance on the steps for my motion to amend?
What?
So I want to, the points Mr. Petersen brought up.
Yep.
Odor footprint study, which I believe was put in the packet today, which I seen in my packet.
Yep.
You know, we talked about manure management, we talked about nutrient management, geological testing. Can you give me the specific requirements so I can put that in my motion?
From my findings here, we have enough evidence we have what it takes to do the conditions on the conditional use permit to offer it from 519, section 519 in Article 5 for a K-full unit for 2,400 units, for 2,400 animals. If you want, if you're going back to saying the applicant has to come back with more information that would be required by the time I issue the building permit anyway, then we have to have all the answers underneath section 519 available to the Board of Adjustment.
And that includes, read them off, please.
That includes that the facility will receive and maintain a general permit by the South Dakota Department of Environmental and Natural Resources, South Dakota Water Pollution Control Act, and the Administrative Rules of South Dakota, Chapter 745201 through 745211. The South Dakota Department of Environmental and Natural Resources directs the animal confinements to have no discharge. The Planning Commission recommended temporary relief for this, but We also will have to have a general permit in which we will have the water pollution control plan, prevention plan. We will also have the animal confinement and waste facilities. The map will have to show us where the public wells are, which we've already identified, but we'll identify them greater. We've already looked. We've had conflicting reports. There are no CAFOs under these requirements, under these applications that are in the floodplain. They are not in the floodplain. Am I clear? Yes. They're not in the floodplain. I'm the floodplain administrator, and they're not in the floodplain. So they are not in there. We do also have to come up with the manure management or nutrient management plan. That means it has to have the maps. That's not going to be done in a month. Now, I don't really care, but that's not going to be done in a month. We're not going to have all those maps done in a month. But that's the other piece. The nutrient management plan has to have all those maps done, along with the soil samples on those farms. The other thing that we have to have here is that land process and methods. How are we going to apply it? And then what fields do we apply it, and what are the buffers on all those fields? Which is something that we were going to ask for when we came into the thing, before we give the building permit. We also then have to have the legal description and maps, which include the documented proof of the area that will receive the nutrient applications. We also have to have an operator must follow the water pollution and protect the public health. We also have to have all the sites appropriately away from any outstanding wells in the area. The operation has to show us how, unless this is where Mr. Petersen comes in under number 10. Animal feeding operations shall prepare a facility management plan. The plan shall be designed to dispose of dead animals, manure, and wastewater in such a manner as to control flies and odor. The County Planning Commission and Board of Adjustment will review the need for control measures on a site-specific basis, taking into consideration prevailing wind direction and topography. The following procedures to control flies and odors shall be applied in the management plan, the management control plan. They have to, in their management control plan, show me the manure collection, treatment, and use shall be done. They have to show the methods to dispose the animals and where will the animals be disposed at and what will be the process on animal disposal. They have to show us the screening. They have to show us the stormwater project and how will that be adequately set up. They have to show us the solid manure management plan. Where is that solid manure going to be stored? Where is it going to be stored? What's the description of how we're going to remove the manure from open pens to minimize odor problems? Well, these are pits. Then they have to show me the industry best management practices that must be covered. Then it goes in the next thing in which we have to have a notification program to the neighbors so that everyone within a half a mile of the application fields is notified when we apply the manure. And that will be a notification program that will be in this best management plan. The next one will be what are the conditions? Do we apply? We don't apply when it's frozen, but we also don't apply when it's the 4th of July. We also don't apply at certain other times because it's not conducive to proper land use. There will be a section in there for preferred times and conditions for application. And then any manure that's being spread will have to be appropriately distanced from any of the wells that are within the findings here. Any manure that is generated, whether it's being applied or it's being generated, has to be a certain distance away from the wells. We are not going to use irrigation to spread the manure with these operations. So there's being no request to do that. So there will be no findings, nor will there be a plan for irrigation manure spreading. What we're going to ask for here, and what Mr. Petersen's pointing at, is saying that, are we being too gracious in saying that, are we approving a plan that could never live up to the expectations? It is so well defined here as to what that plan is that there is no deviating. If they don't come in with that plan, they don't get a building permit. It's not a separate deal. The conditions are attached to the building permit. The conditions are attached to the building. If I end up with an operator that does what Mr. Petersen pointed out and becomes a cooperative operator in which now we have 3 owners that are actually behaving together, and we don't have 2,400 pigs, but we got in another classification, they're violating the conditional use. It's a violation of the conditional use. We bring it back here. We pull the plug. We say, wait a minute, this isn't what we're doing. we're violating the conditional use permit. This conditional use permit is for one pig barn at 2,400 under one operation. If it's not, it's violating the conditional use permit. Now, let's table this. Let's go back and table this. We're just going to make them come back and do all of this.
There's
and
nothing
then what?
that we're going to ask them to do that they don't have to do anyway.
Everything that we're going to have them do,
Just
we're going to
when-
require.
When we ask them to
Yes.
have it done, and then the process of letting the public understand what the manure plan is and what the things that you read off are.
What is the responsibility? What is the responsibility? Put in the condition, we can do it two ways. You can do it the way that Mr. Petersen has said many counties do. There is all clear cut. Everybody knew exactly what everybody said, hey, they didn't all agree, but there it all was out in the front. It all was, laid all out there. Or we can come in and say, we're going to build this as we move through this thing, but here's what you're going to do before we give you a building permit. Now, if there's violations, then that will be dealt with under that realm. But if there's violations, I think we wrote 89 pages of minutes for this thing. We were quite clear as to what we expect from our applicant. There isn't any wiggle room here. We're not being naive and saying that they're going to build something. They're not going to come in and not build that structure, nor give us all the things that needs to go with it, or it won't get built. Now, we can hold it off and go, but we're not going to get that nutrient plan for 6 weeks. Now, that's fine, whatever, but that's how long that's going to take.
You recommending we table it?
No.
Did you say 6 weeks?
I think it'll be a minimum of 6 weeks before we'll see a nutrient management plan. That's a big project and a lot of dollars, but that's beside the point. The fact is, we're still going to make this happen
But
one
they
way or
got to
the other.
spend those dollars anyway.
I know.
Pat,
That's beside the point.
is nutrient management different than what number 10 says in regards to the plan, the facility management plan? The plan shall design the disposal of dead animals, manure, and wastewater, in such a manner to control odors and flies.
And those would be under the management plan. And then the nutrient down there just a little bit further, which then we have to identify the fields, test the soil, assure that the fields are being properly applied, that they're knifed in and not surface or irrigated applied. But that's all detailed in detail in the nutrient management plan.
Questions from the board? Okay, I'm going to ask each board member to...
Don, I was going to amend my motion.
Oh, sorry. Thanks.
My motion is to send this back to the Planning and Zoning Board to have a facility management plan presented to the Planning and Zoning Board, as defined by point 10 in our zoning ordinance under section 519.
Okay, here's a second.
I'll second that.
We have a motion and a second. Any other discussion?
Is there, I'd like to suggest, I heard a month and I heard 6 weeks. How about if we give them 2 months to come up with all the information? That'll give them ample time to think about it, to get everything, because I know how you get holidays, you got family things. We give them 2 months to get all their ducks in a row.
They can take the time as it needs, as I see. They get it done in a month, they can bring it back in a month if it's done in 6 weeks. I want to err on the side of caution with this, is what I'm doing. I see all the hard work and what the applicants have done. They're going above and beyond the minimum requirements. They've hired a third party, which they didn't have to do. They have a Class C facility. It's below state requirements and a state permit. They've done above and beyond. But I'm going to err on the side of caution to delay it, is the reason I made this motion. I've not made up my mind. I just want to make sure we err on the side of caution. This-
Can I speak?
No.
No. Public
Mr.
comments
Chairman,
done.
may I speak to the board?
Public comments done.
We're gonna finish this.
You know, I'm, we have a policy and procedure. We've heard it stated that it's been met. We've heard it stated that there's no problem with the opposition's opposition. A little bit frustrated right now.
Well, here's the deal, the way I'd look at that. And I don't know that if this can be done in the timeframes that we're talking about, but we're asking them to go back and do things that they have to do in order to get this thing approved anyway. So we're not asking the applicants of anything extra, other than they got the risk of whether we can approve it at the end of the time.
I feel a bit.
Okay, so let me finish, Ray. If in fact we move with the motion and Mr. Petersen elects to file a lawsuit, it'll be 2 years before this thing is decided, and I suspect that anybody's interest in whether this is done or not will, at least going forward, it will be gone. So I see that as disastrous if the process is to move forward. And so do the stuff, get it out in the open, let everybody see it. My guess is it'll still be just exactly as you know, it's proposed. They'll get their sites, but I don't know that. But at least everybody can say they looked at all the data. And that's the way I'm looking at it. I want you to have those answers before it goes to, we got to vote. When we vote, then any other discussion? We have a motion on the table. I don't think it's been amended. All in favor say aye.
Don, wait, I would ask for a roll call vote.
Roll call.
Gary,
On the table.
Yeah, we want to table the thing.
All right, the motion is to go back to planning and zoning.
To go back to planning and zoning, that's what it is. I'm sorry, I can't, this thing isn't working.
It's not in your ear.
I'm sorry, what?
It's not in your ear.
Well, just the other part is. Anyway.
Gary,
Yeah, I think it should go back to planning and zoning.
Deb,
Yes.
Todd,
Yes.
Ray,
No.
Don,
Yes.
4 to 5.
Well, that's the first one. We got 6 more.
Mr.
Now, I promised that gentleman that he could speak.
But Jeff, go back.
Come up
Go
to
to
the
the
mic.
mic.
My name's John Reeby. I live at 30626 446 Avenue, Mission Hill, South Dakota. Well, first thing is, I don't know how you just moved on with that at all. We were here for a reason. They were to have all sorts of different plans in place, a site plan for one, and it was stated by Mr. Tom Woods that, you know, we're looking at a Class C facility when you don't even know if it's a Class C facility because, well, you haven't seen the site plan, so you don't know where that manure is going to be spread. You don't know how close these buildings are going to be. So I don't know why you would move forward with any of these, why you would table it, or why you would send it back to the Planning and Zoning Committee. There shouldn't be a case at all. That should have been a no. And Mr. Garrity standing up here as well, I want to point out, there should have been no more talk from him at all. He gets up here, and that was a lot of we statements. We are going to have a plan. We are going to do this. We are going to do that. That's not how it's supposed to be. That is bias. He needs to be recused from this whole situation, as should some of you. Don Kettering, Tom Woods.
My name is Todd.
Todd Woods, Don Kettering. I think you know what you need to do, and you're refusing to do it.
So my question to you is, why should we recuse ourselves?
I don't know. Why don't you look into, your ordinances and see what a conflict of interest is, and see how you would benefit from, maybe anything that has to do with these buildings. You think about that. I don't need to answer your question.
Well, I would like you to answer that question.
Let's let it go. Let's let it go.
If you read through your notes.
I have read through my notes.
Thank you.
Yes, ma'am.
But you have to go to the podium.
You have to get this under control.
My name is Lisa Utek, and I live at 928 Bukowski Drive in Mission Hill. Aren't you two on the Planning Commission? And so you approved this from the get-go, and now you're sending it back to yourselves?
Yeah. Dan? Then we're going to go on to the next one.
Hello, my name is Dan Klemish, Yankton County resident. I'm also a member of the Zoning and Planning Board. I guess I don't understand why we're going to send this back to the Zoning and Planning Board. I brought up many of these issues at the June 13th meeting, and it was just smoothed over. I mean, it was a 7-hour ordeal. But as a member of the Zoning and Planning Board, I don't think that they can take an objective look at this again. I just think, many of the, two of you guys are already on the Zoning and Planning Board. How are we going to get a different result than what we already had? I mean, all these issues were already brought up, and we were told it wasn't an issue and that we didn't need to do this. So I guess I don't understand what going back to the Zoning and Planning Board is going to do for these applications.
Is that all?
Thank you.